Voice of Parliament from
Honorable M.A. Sumandran, you have 18 minutes.
Thank you, Honorable Deputy Chairman of Committees, for the opportunity to speak a few words at this very important debate when the Honorable Minister of Justice has presented to the House amendments to the Code of Criminal Procedure Act and to the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment Act, and certain orders for approval. I must thank the Honourable Minister for remaining in the House after presenting these bills and listening to the various comments that are being made on this matter. The matters that have been placed before the House are very, very important and serious in nature. What we see in the amending act, in both the amending bills, we welcome, because it seeks to make it obligatory on magistrates to visit police stations, and if I heard the Honourable Minister right, not just the police stations but also other detention centres, and examine and see whether the detainees are properly treated, particularly with a view to ensuring that there is no torture or other cruel, inhuman or degrading treatment meted out to them. So, on paper, it's a good move. But one wonders why this window dressing is being made now. If any of us who are aware of the actual situation with regard to torture in this country would wonder why this amendment is being placed today. So much for shouting from the rooftops that we are protecting our sovereignty, we are not bowing down to international pressure and all of that. But all of these facades are being built, and I don't know who you are trying to fool. The Convention Against Torture and Other Cruel, Inhuman, Degrading Treatment or Punishment Act was passed in 1994. And we have various researches that have been made with regard to the efficacy of this act. 26 years of this act has seen just 9 convictions, 6 of which are under appeal. Very recent research publication by Law and Society Trust says that there were only 47 prosecutions. Only 47 prosecutions. Less than 0.1 of the complaints that are made. And one knows that even the complaints are only about 10-20% of the actual happenings. For various fears, fears of reprisals, of further mistreatment, of family members being put in jeopardy, all of those, and only about 10-20% actually make the complaint. And I just worked out the figures. This act, in operation, has been a dismal failure. The calculation, a very generous calculation, will show that only 0.06% of the complaints result in any conviction. Now, how is that to be compared with Article 11 of the Constitution? Article 11 of the Constitution and Article 10 of the Constitution are two provisions that can't be abridged, that can't be restricted. Not by law, not by anything. But we have a situation in this country, time and again, we have judgments from the Supreme Court finding police officers guilty of torture. There are judgments written. Honorable Minister of Justice, being a lawyer, knows that very well. Every volume, every single volume of law reports have judgments of the Supreme Court finding police officers guilty of the most inhuman methods of torture. But they are not brought before court. You have this act to show people around the world that torture is an offense. Today you are even enhancing the fine. What for? You don't prosecute them. Why did you waste this paper? Put it before Parliament. You don't prosecute them. Right? This is to show others. That's why I called it a window dressing. Already, over 100 years, the prison ordinance requires the magistrates to visit the prisons. Do they do that? When did the last time a magistrate visited a prison? I'm asking this question from the Honorable Minister because you may put it here, making it obligatory, that's salutary. How are you going to enforce this? How are you going to enforce a magistrate to visit police stations and other detention centers? Is there a mechanism here to do that? No. There's no mechanism. You already have for 100 years. I have known one or two magistrates, conscientious, have gone and visited prisons, but they don't do monthly, they must do that. They don't do that. And everyone knows that. No mechanism to enforce that. But even if you have a mechanism to enforce that, if the magistrates are not conscientious enough to do what the law has required them to do, can you by force have them do that? No, you can't. Once a special rapporteur of the UN on torture, remember his name very well, Manfred Novak, came and visited places of detention. He was an expert in the field. You must read his report. I think that report came about 15 or 20 years ago, but still valid because he visited a particular place. Then later in the afternoon, he visited the place again. And he found people who were there, not there in the morning, there in the afternoon. He put it all down because those who had been tortured had been taken away and hidden when he went there announced. So he went unannounced in the afternoon and found them. All of those facts are there. Later there is another rapporteur, Mendes, who's given another statement, a report. You allow them to come to this country because you want to show the world that you are open, right? There is no torture. Sri Lanka is one of the worst countries for torture by the police machine. I'm happy that the Minister of Public Security is also here now. We are one of the worst countries. You can say this, you can present this. I heard the minister say, buildings, the hardware, the laws that you have passed is software. And he thinks that that is complete. But where is the delivery? You have made the computer, you have programmed it, but doesn't work. It doesn't work. Even the power doesn't come on in your hardware and your software computer. Right? It's broke. The system, insofar as torture is concerned, your system is broke and you can't fix it by passing these laws. Now, one word about Prevention of Terrorism Act. Torture in this country became an epidemic because of the provision in the PTA that enabled, that allowed confessions made to police officers as admissible evidence. That's how torture became endemic. That's how police officers lost their ability to investigate offences. They no longer had to investigate offences. That skill disappeared long ago. All you had to do was beat up a fellow, or do worse, get his signature. You solved the crime. I have demonstrated, I don't want to repeat this. I have given stories after stories after stories where crimes are supposed to have been solved because you have a confession. You convict the wrong person. But what is dangerous in that is that the real culprit is still roaming free, is still there out on the street. That is what is dangerous about this. If you are only concerned about national security, you say, your national security is gone. Because the one who actually committed the crime is out there. And you have got somebody else, got a confession, and put him behind bars. So even from that point of view, not just from the human rights point of view, not from the human dignity point of view, even from your avowed national security point of view, it's a dismal failure. The European Union has passed a resolution that they're withdrawing GSP+. Why? Because in 2017, a guarantee was given by the then government that they will repeal the PTA and replace it with another law that is compliant with international human rights standards. Some effort was made. When they came up with the CTA, I was the first person to publicly announce that this is worse than the PTA. Subsequently, it came to various parliament committees. EU representatives also came to see whether it was compliant. And we worked on it, and various amendments were brought in. It wasn't perfect, but it was 100 times better than the PTA that you have. It was 100 times better, I repeat, it's 100 times better than the PTA that are still on our statute books. But it wasn't passed, unfortunately, because several of our civil society people thought we must only have a perfect law. And so we now have the PTA, because we couldn't have the perfect law. There were shortcomings in that, but it was far better. Honorable Lakshman Kiriyala mentions certain matters. Confessions cannot be admissible. In our country, in this culture, confessions made to a police officer cannot be admissible. Preventive detention cannot be permitted except for a very short period of time and with judicial supervision. There are numerous issues with regard to the PTA. Honorable Minister, I can tell you very responsibly, you can't amend the PTA. You have to repeal the PTA. The whole basis, the foundation of that law is flawed. I have said this several times. It was brought just for 6 months. It still bears that name, Temporary Provisions Act, brought in 1979. You have to repeal it. We also agree that all the countries in the world have laws to deal with terrorism. We don't say no to that. We don't say no to that. But that must be done without, I agree with you, there has to be a balance. Right? But that balance has to be struck properly. You can't have Article 11 in our Constitution and then allow even one person to be tortured. I agree with you on that. It's not the numbers. But you did speak about numbers, about the disappeared. And I heard you say that people are making allegations that Thousands of people have gone missing. Not people are not making allegations. Your own government appointed commissions have said so. Leave aside what we say. Your own commission, Paranagama Commission, says more than 20,000 people. What have you got to say about that? Your own commission, Udalagama Commission, says, with regard to just the two matters that they inquired into, the 17 aid workers in Mudur and the 5 students in Trincomalee.
Honorable Member, you have 2 more minutes.
How many?
2 more minutes.
Thank you. They have said that. Your own commission, all these 3 commissions, LLRC, all those 3 commissions were appointed by President Mahinda Rajapaksa, has said that persons who were surrendered to the security forces at the end of the war have gone missing. They have given the number 3,000 odd. They have given the number. Your own commission. We had nothing to do with those commissions. When your own commissions have said tens of thousands of people have gone missing and not one has been traced so far, not one has been prosecuted for that, what's the point in saying people are saying? You have said it. You have admitted to it. Why can't you investigate one case? 11 young people were abducted by personnel of the Navy in Colombo, not because they were involved in anything, but for ransom. Senior naval officers were involved in that. You interfere in that. You go after investigative officers in that case. You waylay that case, and then you preach sanctimoniously here that this government will protect the dignity of everyone. How do you make these ends meet then? If you are sincere, and I'm saying,
Honorable Member, please wind
that
up.
you are not sincere. This is just window dressing for the European Union. And it's too late. And I want the European Union and the entire world to know that this is just eyewash. A very weak and feeble attempt by this government to try to show that you are human rights, international human rights compliant. That will not work. Unless you make a genuine turn, you will not succeed in this false effort of yours. Thank you.
Thank you. Honorable
ගොස්තුති ඔබතුමාට මිළඟට රවුෆ් හකීම් මැතිතුමා ඔබතුමාට විනාඩි 11ක කාලයක් තියෙනවා.
Thank you, Honorable Presiding Member. We are trying to pass some of these legislations today as an attempt to improve our criminal justice system when it comes to the liberty of the individual. Now we talk about today in this morning or this afternoon, the Honourable Minister was heard to say that, that the government follows a policy of zero tolerance against torture. Now these are all very pious words. These are all utopian, I would say, utopian dreams. But then, to make it a reality, there needs to be paradigm change in the manner in which we administer our criminal justice system. It is a known fact that torture is an endemic problem in the culture of policing in this country. Together with that comes the need to have a relook at the Prevention of Terrorism Act. Several speakers before me had talked about the Act itself being a very temporary one when it was enacted way back in 1978. But in its implementation, we have found that it has paved the way for terrible abuse of suspects in custody. particularly when it comes to torture. Torture is not simply physical torture. What about the mental trauma that you subject an individual when you subject him to administrative detention without any judicial supervision for months on end? For almost 1.5 years, you can keep somebody incarcerated without any judicial supervision. So this is a very draconian piece of legislation which must be revised, and we must bring an end to this endemic culture of torture. Now, in order to do that, now we must also remember that we have now arbitrary detention finally ends up in facilitated torture. You facilitate torture by arbitrarily detaining somebody. We have several such people in such detention centers in several places in this country. So, now I would quote here, in 2017, the United Nations Special Rapporteur on Human Rights and Counterterrorism said this: "This has fostered the endemic and systemic use of torture." That is the Prevention of Terrorism Act. Entire communities have been stigmatized and targeted for harassment, arbitrary arrest and detention. We saw what happened after the Easter Sunday attacks. Almost 2,000 to 3,000 Muslims are arrested en masse and detained. Subsequently, over a long period of time, one by one, several got released. There are 200 others in custody. And among those are some young people who have even got university entrance. Some have even got entrance to medical college. There are engineering students under custody. Now these young people, now without any, if there is substantial evidence, bring them before a court of law, charge them. But then now you are adopting another procedure, which some dictatorial, despotic countries have adopted, which are to set up detention centers where you go with a de-radicalization program. You have already published a gazette. But then there are certain anomalies in that. If you want to de-radicalize somebody, first produce the evidence before a judge and show why he had been held in custody, why he should be de-radicalized. What are the reasons for it? So you use various other provisions. Now you have had several other notable detainees we have talked about several times. Mr. Hijaz Hezbollah, a young lawyer who had been in detention for a long time. Now you have decided to file a case against him under the ICCPR Act, under hate speech provisions. Up to now you have only been able to do that. And you have known to have tortured and pressurized witnesses to incriminate him, saying that he took part in various radicalization classes, which is all a figment of the imagination of some of those people who have other vested interests to achieve. So the abuse of these provisions has finally resulted in the European Union looking at it from a point of view of, in a roundabout way, bringing some economic sanctions. Economic sanctions, when I say, the preferential tariff arrangements are in danger today because of our attitude towards the people who are under custody. Now you go and pardon 16 detainees who are under PTA. And under that pretext, you slowly also pardon a murder convict to appease one of your supporters who has a very popular TV station, who has been singing your hosannas for several years now, who are responsible to even bring you to power. There are two specific TV stations, they have been amply rewarded by several means. Some are being also awarded tenders to buy all types of, antigen tests and test kits and all sorts of things are happening. Now, these things are being monitored and looked at. So, now in order to, if you look at what is happening in the outside world today, it's very obvious. The government is becoming unpopular by the day. So you need all these friends who run electronic media to boost your sagging morale. So what do? You go and pardon 16 PTA detainees along with the person whom you have given a pardon when he had been under a death sentence, confirmed by 5 senior judges of the Supreme Court. So now that is a very cynical move. It is seen as a cynical move for nothing else. Because among these 16 detainees, most of them have already been under detention for more than 10 years. Some of them, even if they are convicted, even the sentence, they would have already served, having been there for so many years. So there is nothing surprising when, this is why such cynical moves will be laughed at by the international community. Already we have invited a lot of wrath from well-meaning friends among the international
Honourable
community.
Member, you have 2 more minutes.
Yeah. Now let me also come to some of these other issues. Now particularly the Criminal Investigation Department, the Attorney General's Department, all these departments are departments who had a certain sense of pride in their work. They were seen as a very independent institution. Because of unnecessary politicization and pressure, they seem to be losing their independence. Now, you appoint a presidential commission against political victimization, and some of the commissioners are instructing the Attorney General's Department to discontinue cases which have already been filed in courts and which are in the process. So, and the Attorney General openly comes and protests about this. And you are also blaming and passing strictures on members of the Aegis Department who have sincerely done their duty and work. So such is an attempt that is causing all these problems for us in the international arena. So we need to have a relook at all these things. We need to have some reform in these areas. Now, particularly, I would urge the Honourable Minister to look at this so-called de-radicalization gazette and its the manner in which it is going to be implemented. I saw that you have now enlisted some Muslim theologians, learned men to de-radicalize these young people. By doing such a program without sufficient evidence against them, you will only radicalize them rather than re-radicalizing.
Honourable Member,
This is
your
what
time
I
is
feel.
up. Please wind up.
So therefore, these matters that we looked at with a different approach, and then some of these issues needs to be corrected. And also I would here talk about the Office of Reparations. Now, the Honourable Minister said that this was a substitute
Member,
for RIPIA.
please
Now,
wind up.
there are several compensation issues pertaining to the Digana riots, and then the riots in Ampara, then in
Honourable
Kurunagala
Member,
district.
your time is up. Please wind up.
Pending compensations, which are in large amounts, are still to be doled out. And therefore, those people who have suffered serious property damage
Thank you.
has to be compensated. I hope the government will look into it and have those matters also attended through the Office of the Reparations very soon. Thank you.
Thank you.
ගරු සභාපතිතුමනි විශේෂයෙන්ම අද අපරාධ නඩු විග්‍රහ නඩු විධාන සංග්‍රහයේ සංශෝධන කීපයක් ගෙනීම ගැන අපි විපක්ෂයේ හිටියත් අපි හිතනවා ඒවා හොඳ ධනාත්මක සංශෝධන. ඒ වගේම තමයි මේ සංශෝධනවලට මම අපි මේ විශේෂයෙන්ම කමිටු අවස්ථාවේදී යෝජනා කීපයක්ත් තියෙන ඒ සංශෝධන වලට ගේන්න එකතු කරන්න විශේෂයෙන්ම මේ මහේස්ත්‍රාත්වරුන් පොලිසියට යාම හා පොලිසිය පමණක් නොමෙයි අපරාධ පරීක්ෂණ දෙපාර්තමේන්තුව ත්‍රස්ත විමර්ශන කොට්ටාශය එවගේම විශේෂයෙන්ම රැඳුම් නියෝග මත රැඳුම් කඳුරල ඉන්න අයවත් බැලීමට අවස්ථාව ඒ මයස්ථාතුරට ලබා දෙන්න ඕනේ කියන සංශෝධනය ඉදිරිපත් කරන අපි හිතන අධිකරණ ඇමතුමා ඒකට සහයෝගය ලබා දීලා ඒ සංශෝධනයත් ඉතාම ප්‍රගතිශීලී සංශෝධනයක් ඒක ඉදිරියට ගෙනියයි කියලා. ඒ වගේම කරු සභාපතිතුමනි මේ විශේෂයෙන්ම අද අපි දන්නවා අපේ රටේ මේ විශේෂයෙන්ම රැඳුම් නියෝග මත ඒ වගේම රිමාන්ඩ් බන්ධනාගාරවල තවම නඩු පවරන්නේ නැති විශාල පිරිසක් ඉන්නවා. ඒ පිරිස අවුරුදු 2-3 නෙමෙයි ඊට වඩා එහා ගිය පිරිසක් ඉන්නවා. ඉතින් මං හිතනවා මේ පිරිස ගැන රජය කඩිනම් අවධානය යොමු කරන්න ඕනේ. මම දැක්කා ගෝඨාභය රාජපක්ෂ මහත්තයාගේ සෞභාග්‍ය දැක්මෙත් තිබෙනවා විශේෂයෙන්ම වසර ගණනාවක් රිමාන්ඩ් බන්ධනාගාරවල ඉන්න අය ගැන ඉතා ඉක්මනින් ක්‍රියා කරනවායි කියන පොරොන්දුවකුත් ඒ සෞභාග්‍ය දැක්ම තුල අඩංගු වෙලා තිබෙනවා. ඉතින් අපි දන්නවා අද වෙනකොට විශාල පිරිසක් ඉන්නවා. විශේෂයෙන් විශ්වවිද්‍යාලවලට තේරීපත්‍ය ශිෂ්‍යෝ 5 දෙනෙක් 6 දෙනෙක් විතර වගේ අවුරුදු 1.5ක් දෙකට ආසන්න කාලයක් කිසිදු ආකාරයේ චෝදනාවක් නොමැතිව නඩු පවරන්නේ නැතුව තවම රිමාන්ඩ් බන්ධනාගාරවල ඔවුන් කාලය ගත කරනවා. ඒ හින්දා අපි අධිකරණ ඇමතුමාට කියන ඔවුන්ගේ අනාගතය ගැන හිතන්න. ඒ තරුණ අය ඔවුන්ට චෝදනා තියෙනවා නම් ඒ චෝදනා ඉදිරිපත් කරන්න. එහෙම නඩු දාන්න පුළුවන් සාක්ෂි කියනවා නම් ඒව නඩු දාලා ඔවුන් නඩු පවරලා ඒක ඉස්සරහට ගෙන යන්න. එහෙම නැතුව නිකන් ඔවුන්ව ඒ රඳවුම් බාරේ හරි එහෙම නැත්නම් රිමාන්ඩ් බන්ධනාගාරය තුල ඒ තරුණ පිරිස් රඳවා ගැනීම තුල ඔවුන්ගේ අනාගතයේ සම්පූර්ණයෙන්ම විනාශභාවයට ලං වෙනවා. ඒකේ සමුන්නාන්සලත් ඒකේ වගකිය යුතු කොටස්කාරයෝ බවට පත් වෙනවා කියන එක මතක් කරන්න කැමතියි. ඒ වගේම තමයි ගරු සභාපතිතුමනි මම මතක් කරන්න ඕනේ විශේෂයෙන්ම 2020 නොවැම්බර් මාසේ 24 වෙනිදා ශ්‍රී ලංකා මානව හිමික කොමිෂන් සභාව විසින් පොලිස්පතිතුමාට යවපු ලිපියක් තියෙනවා. ඒ ලිපිය මම සභාගත කරනවා. මේක ලිපිය තුල තිබෙන ප්‍රධාන කාරණාව තමයි විශේෂයෙන්ම රැඳුම් බාරවල ඉන්න ඒ වගේම පොලිස් අත්අඩංගුවල ඉන්න උදවිය සම්බන්ධව අපරාධ පරීක්ෂණ දෙපාර්තමේන්තුව මගින් ලබා දීලා තියෙන වාර්තාවක් පාපෝච්චාරණය කරන අය හා පාපෝච්චාරණය කරන්න අවවාද කරා කියලා මේ ලයිස්තුවක් ලබා දීලා තියෙනවා. ඒ ලයිස්තුව අනුව අපිට පෙනී යන දෙයක් තමයි මානව හිමිකම් සංවිධානය අපේ ලංකාවේ ඔවුන් පොලිස්පතිතුමාගේ ඉල්ලා සිටලා තිබෙනවා විශේෂයෙන්ම මේ පිළිබඳව පරීක්ෂණය කරන්න කියලා. මොකද පාපෝච්චාරණය කිරීමට අවවාද කිරීම කියන එකත් වද හිංසාවක්. ඒකත් බලාත්කාරකමක්. එහෙම කරන්න බෑ. එතකොට අද මේ රැඳවුම් කඳවුරු වල ඉන්න එහෙම නැත්නම් ත්‍රස්ත විමර්ශන අංශවල ඉන්න එහෙම නැත්නම් අපරාධ පරීක්ෂණ දෙපාර්තමේන්තුව වගේ අත්අඩංගු වල අරගෙන ඉන්න අයට යම් බලපෑම් සිද්ධ වෙනවා. ඔවුන්ව පාපෝච්චාරණය කරන්න ලෙස ඔවුන්ට බලපෑම් කරනවා. අන්න ඒ පිළිබඳව ශ්‍රී ලංකාවේ මානව හිමිකම් කොමිෂන් සභාව අපේ පොලිස්පතිතුමාට දැනුම් දීලා තිබෙනවා නොවැම්බර් මාසේ 20 වෙනිදා 2020. එහෙනම් අපි අධිකරණ ඇමතුමාට කියනවා ඒ පිළිබඳව එතුමාගේ අවධානය යොමු කරලා ඒවට ගත යුතු ක්‍රියාමාර්ග ගන්න කියලා අපි එතුමාට කියනවා. ඒ වගේම තමයි ඊළඟට විශේෂයෙන්ම අපි දන්නවා දේශපාලන වශයෙන් පරිගැනීම් ලක්වුවන් ඉන්නවා මේ නඩුවල. රිෂාඩ් බදුරුද්දීන් ඇමතුමා හිටපු ඇමතුමා ඉන්නවා ආණ්ඩුකාරතුමා ඉන්නවා හිටපු ආසාද් සාලිම් ඇමතුමා ඒ වගේම ඉජාස් ඉස්බුල්ලා අපේ දක්ෂ නීතිඥවරයෙක් මං හිතනවා අධිකරණ ඇමතුමාත් එක්ක සමකාලීනව උසාවි වල කටයුතු කරපු නීතිඥවරයෙක් එතුමා අපි දන්නවා අද දේශපාලන පරිගැනීමකට ලක් වෙලා ඉන්නවා. ඉජාස් ඉස්බුල්ලාට මේ සිදුවීම සිද්ධ වුණේ විශේෂයෙන්ම දින 52 ඒ අර හොර ආණ්ඩුව පත් වුණාම එතුමා අපේ ආණ්ඩුව පැත්තෙන් එතුමා විත්තිය වෙනුවෙන් එදා පෙනී හිටියා. ඒ පෙනී හිටියට ඒ පරිගැනීමක් හැටියට තමයි අද ඉජාස් ඉස්බුල්ලාව බොරු චෝදනා මත දාලා එතුමාට චෝදනා විතරක් නෙමෙයි ළමයි අල්ලලා ඒ ළමයින්ට බලපෑම් කරලා ඉජාස් ඉස්බුල්ලාට විරුද්ධව කට උත්තර දෙන්න කියලා බලපෑම් කරලා අද එතුමාව තියාගෙන ඉන්නවා. අවුරුද්දක් අද පහු වෙලා තියෙනවා. තවම චෝදනාවක් එල්ල කරගන්න බැරි වෙලා තියෙනවා. තවම පරීක්ෂණ අවසන් කරගන්න බැරි වෙලා තියෙනවා. හැමදාම කියනවා පරීක්ෂණ කරනවායි කියලා. ඒ වගේම තමයි ගරු සභාපතිතුමනි අවසාන වශයෙන් කියන්න ඕනේ විශේෂයෙන්ම මේ නඩුකාරයන් ඉල්ලා අස්වීම පිළිබඳ ශ්‍රේෂ්ඨාධිකරණේ. ඒක මේ රටේ ශ්‍රේෂ්ඨාධිකරණයට විතරක් නෙමෙයි අපේ නීති පද්ධතියට අපිට තියෙන ගෞරවය නැතිවීමක්. අපේ ගෞරවයට හානියක්. අපේ නීතියට හානියක්. මොකද ශ්‍රේෂ්ඨාධිකරණයේ නීතිඥව විනිශ්චයකාරවරු නඩුවක් එනකොට ඒ නඩුව ඉස්සරහට ඇවිල්ලා මම මේ නඩුව කරන්නේ නැහැ කියලා කියනවා කියන්නේ ඒක බරපතල ජාත්‍යන්තර වශයෙන් අපේ උසාවිවල් හැල්ලු කිරීමට ලක් වෙන විතරක් නෙමෙයි වින්දිරයට කරන අපරාධයක් ඒක. මොකද ඔව් මාස දෙකක් තුනක් ඔව් ඉන්නවා අද රැඳවුම් නියෝග මත ඔහු උසාවියට නඩුවක් දැම්මම විනිශ්චයකාරවරු 4 දෙනෙක් අද වෙනකොට ඉල්ලාස් වෙලා තිබෙනවා. ඒ හින්දා මම හිතනවා ඒක අපේ ක්‍රමවේදයේ තිබෙන විශාල අඩුපාඩුවක් විතරක් නෙමෙයි ජාත්‍යන්තර වශයෙන් උත් අපි හැල්ලුවට ලක් වෙන කාරණාවක් හැටියට අපිට ඒක මතුවෙන්න සිද්ධ වෙනවා. ඒ හින්දා අපි කියනවා අධිකරණ ඇමතුමාට මේ පිළිබඳව එතුමාගේ අවධානය යොමු කරන්න. එහෙම විනිශ්චයකරුවන් තමන්ට ආපු නඩු ගැන තමන් එදා උදේට ඇවිල්ලා කියනවා නම් මම මේ නඩුව බාරගන්නේ නැහැයි කියලා. ඒ වගේ දැන් විනිශ්චයකාරවරු 4 දෙනෙක් රිෂාඩ් බදුරුදීන්ගේ ඇමතුමාගේ ඒ නඩුව වෙනුවෙන් පෙනී හිටින්න ඕන විනිශ්චයකරුවන් 4 දෙනෙක් ඉල්ලා අස්වෙලා තියෙනවා. ඒ වගේම ගරු සභාපතිතුමනි අපි විශේෂයෙන්ම අද විශාල පිරිසක් අත්අඩංගුවට ඉන්නම ගැන විශේෂයෙන්ම අද අවුරුදු 1මාර 2 3 4 විශාල වශයෙන් අද අත්අඩංගුවට රඳවාගෙන ඉන්නවා නඩු නැතුව. ඒ වගේම ඔවුන්ව උසාවියට ගේනවා නීතිපති දෙපාර්තමේන්තුවෙන් චෝදනා එල්ල වෙන්නෙත් නැහැ. නැවත ඔවුන්ව රිමාන්ඩ් බන්ධනාගාරයට ගෙනියනවා. එහෙම විශාල වශයෙන් අද මේ රටේ ඉන්න විශාල පිරිසක් ඉන්නවා. ඒ හින්දා ඒ පිළිබඳව ඉක්මනින් ක්‍රියාමාර්ග ගන්න. ඒ පිළිබඳව ඉක්මනින් ක්‍රියාත්මක වෙන්න. මොකද අපි එක පැත්තකින් අපි ඒ වින්දිත් ඔවුන් චෝදනාවලට ලක් වෙලා තියෙන අය නම් ඔවුන් වැරදක් කරලා තිබෙනවා නම් ඒ පිළිබඳව සාක්ෂි තිබෙනවා නම් ඔවුන්ට අවශ්‍ය නඩු ගොනු කරලා ඔවුන්ව නීති ඉදිරියට පමුණුවලා ඔවුන්ට දඬුවම් ලබා දෙන්න. ඒ ගැන අපිට ප්‍රශ්නයක් නැහැ. ඒ වගේම ගරු සභාපතිතුමනි අපේ මෙතන ඉන්නවා අපේ අධිකරණ ඇමතුමා ඉඳ මම එතුමාගෙන් මට ප්‍රශ්නයකට මම එතුමාගෙන් පිළිතුරක් බලාපොරොත්තු වෙනවා මේකෙන් අවසන් කරන්න honorable minister, you know, now these days there is in the media there is a media publication going on about the Qazi Court. I don't know whether you are the minister of the cabinet for the law and order.
මීළඟට ගජේන්ද්‍ර කුමාර් පොන්නම්බල් ගරු මන්ත්‍රීතුමා ඔබතුමාට විනාඩි 8ක කාලයක් ලැබෙනවා.
8 minutes.
8 minutes.
Thank you. Honorable Presiding Member, I thank you for giving me some time to make a few comments under this head. I would like to mainly restrict my comments with regards to the OMP, Office of Missing Persons. I think initially I'd like to welcome the amendments to the Code of Criminal Procedure and even the law on the Convention Against Torture. Those are no doubt forward-moving steps. But as several members of this House have repeatedly stated, primarily from the opposition, I think implementing these laws is a crucial matter that I'm sure the Honorable Minister of Justice is fully aware. I mean, this is a country that has a legacy that passed the 17th Amendment to the Constitution, which is the supreme law of the country, and never implemented it when it came to the appointment of the Constitutional Council. At that time, it was a different president. She herself was involved in bringing the law, but eventually never appointed that Constitutional Council. And that was an amendment brought to the supreme law of the country, supposedly the Constitution. So I think there is a valid point made by the opposition members with regards to implementing these amendments. The legacy that this country has created, I think, is appalling on that matter, and as a result, there is grave doubt with regards to the credibility of the entire judicial system. So apart from those comments, I would like to talk about the Office of Missing Persons. Honorable Presiding Member, the Office of Missing Persons and the Office of Reparations were created consequent to Resolution 30/1 in the UN Human Rights Council. That was a resolution that was brought with the consent of the previous government. Now, whilst the present government vehemently criticized Resolution 30/1 and called it a treacherous act, we, on the other hand, and I am someone who goes to the Human Rights Council sessions as often as possible, we criticized 30/1 as a complete betrayal of the victims. You see, a country-specific resolution was primarily mooted on the grounds that heinous crimes had taken place and accountability was required. Instead of accountability being looked at, Instead, the previous government managed to succeed, in my view, in actually getting Sri Lanka out of the clutches of the need for accountability by showing ancillary matters, by showing fringe issues as progress. And one of those was the Office of Missing Persons. Now, the Office of Missing Persons, there is a procedure within the UN Human Rights Council and also in the UN structure itself that whatever decisions are taken should be victim-centric. That victims must have confidence in the process. Because if you don't have the confidence of the victims on board, they are not going to cooperate with whatever steps that are taken. Now, the Office of Missing Persons was created when the victims had given so many recommendations. None of those recommendations were taken by the previous government, and the previous government ignored those recommendations in creating the Office of Missing Persons. And the victims of forcibly disappeared people have repeatedly complained that there is no credibility with regards to this office. And let me just very briefly read some of these complaints that they have in fact put forward in writing. How do you expect the OMP to bring justice? I'm quoting here. How do you expect the OMP to bring justice to us when OMP Act Section 13, subsection 2 mentions that the findings of the OMP could not be used in any civil or criminal cases for seeking justice? There is no transparency adopted to the selection of the commissioners for the OMP. Selections were made by the Constitutional Council in which Sinhala politicians are also members who repeatedly said that they will not allow any members of the security forces to face justice. Can OMP guarantee that alleged perpetrators will be brought before justice? Out of the 7 commissioners in the former senior security forces officer, how can we go to seek justice from him? Can the OMP take steps to remove his as its commissioner? Like that, they have listed so many, and so many valid doubts. And today, the victims of the forcibly disappeared in the north and the east, the Tamil victims, do not in fact have confidence in the OMP.
Honorable member, you have 2 minutes.
Yes. Do not have confidence in the OMP or in the Office of Reparations and are boycotting it. A vast majority of victims refuse to go before the OMP. So it is in that backdrop that the OMP was approved by the previous government in this House. And it is for that reason of window dressing, just to show the international community some progress being made, quote unquote, that these officers were created, and thereby the previous government managed to prolong the question of accountability for 6 years without any progress being made at all. And therefore, Honorable Presiding Member, it is not surprising that this government itself, the only officers that they are willing to hold on to, that was created by 30/1 resolution, being the OMP and the Office of Reparations. I think it is tragic, Honorable Presiding Member, that we still, after 12 years of war, cannot understand that grave crimes were committed against ordinary people, and that it is the duty of the state to protect their people. And that if in fact those crimes have been committed by the armed forces, then those must be prosecuted. That even 12 years after the war, knowing fully well, and these are responsible members who are holding office today, knowing fully well that crimes have been committed, that we just simply refuse to even go into it, I think clearly shows how tragic this country is. And
Honorable
quite
member,
honestly,
time is over.
for as long as this culture continues, we will only create
ගරු උදේන
and
කිරිවර
perpetuate a
ගරු
system
මන්ත්‍රීතුමා
of
ඔබතුමාට
impunity.
විනාඩි
Thank
10ක්
you.
කාලයක් ලැබෙනවා.